Thank you, Mr. Chairman. Yeah, thank you very much. Very good hearing. Appreciate it. Mr. Koppel, is that right? Are you still with us?
Yeah, I hope so.
Okay. Well, I enjoyed our last engagement where we're trying to find a way on the front end and the back end to give adequate due process, but also address the problem. And I think the Indiana situation is a good one. And Ms. Gozar, is that right? You, your story made me think about, we want to make sure we're thinking this thing through and not go too far with it. But I've just come to believe, Mr. Chairman, like you have, that states who've adopted these laws probably are on the right track. The Cruz situation in Parkland, 30 visits by the police, every warning sign known to mankind, and they were powerless. And Governor Scott, working with the State House, passed a Florida version of the red flag laws. Indiana was one of the first ones to do this. And the situation where the young man had the shotgun taken because of his mental health status, but there was no implementation, is something that I'm sure we don't want to have happen again. So, Mr. Koppel, when it comes time to write a grant program, let's say, incentivizing states to go down this road on the due process front, you're advocating that there be a civil cause of action in case somebody is accused wrongfully or maliciously, that they can actually have recourse against their accuser. Is that right?
Yes, not a mistaken accusation because everybody makes mistakes, including me, as we discussed
Yeah.
earlier in this hearing. But a knowing
Gotcha.
false and malicious
Well,
accusation.
so I talked with the chairman about that. That makes sense to me that if somebody is trying to ruin your life and accuse you of something you're not, then they'll have a redress. So I like that. The ex parte nature of the hearing, the initial determination by the judge to act. What kind of standard would you suggest we create there?
I'd say start with the federal rules of civil procedure, which generally disfavor ex parte decisions, but allow a judge to issue orders ex parte on a guided set of facts and findings about necessity. And particularly, why is the other person not here in court? Why didn't this person have notice? And sometimes the person seeking a temporary restraining order can give a good answer to that, and sometimes not. And I'm
So
sure in these
the
situations,
preference would be in live testimony so the judge could ask questions, but what
yeah,
standard would you impose?
the same as Federal Rule of Civil Procedure 59,
Okay, all right.
on which I am not an expert.
No, I got you, but you got to pick a standard. That seems to be a good one to me. Uh, the time period between the initial determination and a full blown hearing, what would you recommend?
I'd suggest we talk to prosecutors and including some of the witnesses here who have experience with this and say what is a realistic uh, time period. On the one hand, we want to be expeditious. On the other hand, maybe there's some time needed to gather
Okay,
evidence. And
all right. Based on your research of the existing state laws, which one do you think has done the best job of threading this needle, and why? And which ones do you have the most concern about, and why?
Uh, Vermont may be best overall, although Connecticut has some good features in it too, and especially the requirement that law enforcement investigate the situation on their own before filing a request for a petition. Colorado, with its providing for defenders, uh, defense lawyers in this case, I think is a very strong model and not only helps the individual, but I think also may function as a deterrent uh, to potential abuses. On the other side, I'd say Massachusetts has some of the weakest standards for due process. In New Jersey, actually, once you've got the person actually gets an in-person hearing and there's a confiscation order, it has the effect of being permanent, preventing the person from ever owning a gun again unless they come back into court and prove that they're not a danger. So I think the model Mr. Horowitz's organization has talked about, where the order automatically terminates after a certain period of time, it can be renewed upon new further proof about the individual at that new time, is the better way to go.
Okay, well, just sum it up here. I don't want to go over. Basically, you believe the most constitutionally sound way to do this would be not a federal law, but some grant program that would emphasize adequate and robust due process. Is that fair to say?
Yes, and I think that the states and localities have the resources to do this in a way that the federal marshals and others just don't have the manpower for, among other reasons.
Thank you.